I have selected 3 cases for this episode for my subscribers, as I wanted to point out a couple of things that the Defense Counsel does and doesn't do. And I also wanted to show you a rule of thumb when it comes to the US courts of law that will help you if you ever end up in court. You can thank me later. Just make sure you subscribe. Welcome to Off the Record.
Could you state your name for the record?
Omar Anderson. Thank you.
Your Honor, I was just informed last night that there are some jail calls that were delivered to my inbox after the beginning of this docket today. So I would like to ask for an adjournment so that we can listen to those and decide on how to proceed from there.
Go ahead. What?
That is correct, Your Honor. He was arraigned on May 31st, and between May 31st and prior to his release on June 3rd, including on June 3rd, he made 8 calls to the victim. I do want to note that the underlying allegations here is that he had a valid and served PPO protecting the victim. At that time, he came out and threw a brick through the back windshield of her car, which damaged the front windshield of her car as well, and then fled the scene. Since the calls from the victim, to the victim from when he was in custody, she has since filed to terminate the PPO, and he has been out. I am extremely concerned that
I just want to make sure I'm clear. There was a PPO.
Correct.
He is lodged at the jail at some point.
Correct.
From the jail, there are calls being made.
Correct. After his arraignment.
Go ahead.
I am extremely concerned at the potential for undue influence on the defendant's part over the victim.
Counsel. Mm-hmm.
Your Honor, as I have not had a chance to review any of the information, I just know that there were calls. Again, I would ask for an adjournment.
But how many calls between the time that he's incarcerated and arraigned and released? How many calls?
8.
You have copies of the calls?
They were just released this morning.
I have not had a chance to download them.
Because I'm going to let you know, Mr. Allen, my inclination would be to remand him pending some resolution as to what's contained within those calls, because he shouldn't have been contacting her at all. Yeah, the defendant's bond at this point will be revoked, because I think that his bond, there would have been differences. I need to figure out what's in these calls. And here's the reason, Ms. Reed, I want to figure that out. There are these calls being made. There's a PPO in place. There are these calls being made. The PPO is then requested to be lifted, and then this case is still here. And there's a lot of little flags raised by that. So I'm going to revoke his bond. I will give you an opportunity to whoever in your office to try to get through those calls. And then I will consider at any point in time, a request to change that or to do something else. But I think everybody needs to hear, or at least try to hear, what's on these calls. All right.
Do you want me to release the calls to your chambers as well, or?
Why don't you? Because that would then speed up the process if Ms. Reed has something that's in the calls or something that she wants to say why or whatever, or the people for that matter. I don't have to then try to reach out and get them. So yeah, why don't we do that? You wanted this adjourned, correct?
That is correct.
All right, since I'm remanding him, I'm going to put it out just 1 week to the 20th.
Thank you.
So probable cause will be adjourned to June 20th, 2024, 9 a.m. or your invite indicates bond is revoked at this point. Defendant's remanded.
I don't think the call's right.
Can you give the keys to
Privilege is right. Revoked is back.
I just revoked it.
Coach, we've got 2 matters with you today. We'll call them both at the same time. State of Michigan versus Volante Deshaun Coates.
My client waived his right to formal reading, was advised his constitutional right, so stand mute.
Court will enter a not guilty plea on your client's behalf as to bond.
Your Honor, Mr. Coates, the people are going to ask for a bond of $35,000 personal with a tether. In both matters, Your Honor, Mr. Coates is, we believe, a flight risk, but also a danger to this complaining witness, as it's the same complaining witness in both cases. Your Honor, there's a reference to a son. The person who is mentioned in the it's like the July incident, where they refer to a witness who said that they saw Mr. Coates push the complaining witness against the wall. That is the son of the complaining witness. I'm not sure if it's Mr. Coates' son, but that child is 16. There's a reference to the June incident about the complaining witness locking herself and her son into the bedroom out of safety, and Mr. Coates allegedly kicking the door at that point. So we do have concerns for safety, given he's allegedly punching somebody awake, and then at a different incident, allegedly pushing them into a wall in front of their child. There is in the incident report, and I did send Mr. Bird an email, the complaining witness is saying that she is pregnant. So we have concerns here for safety. He does have as far as priors go, he did have a 2010 A and B, 2013 R&O. He had a 2013 unarmed robbery, Your Honor. And as far as flight risk goes, that's based on Otis and Lean showing him as an absconder from probation. Otis is showing that he has a absconder date of November 16th, 2020, and that is in a case out in Livingston County for convictions, 2 counts of delivery manufacture of an imitation substance. I did email Mr. Bird the register of actions on that, as well as the Otis, Your Honor, and he had according to the register of actions, there was looks like a bench warrant was initially issued November 13th of 2020. So a few days before he was designated an absconder from probation. And then there was an amended request and warrant for probation, amended request and warrant for probation violation, September 8th of 2022, based on the register of actions. And he's never been arraigned on that. And so, Your Honor, I did look at the lien to see if that was still valid, because sometimes there's a lag in updating on the Otis, and lien is showing him still as an absconder from probation. So absconding from probation for 4 years, and then now we have him allegedly assaulting the same woman twice, one time in front of her child, and one time it's not clear who the child is who's being referenced. And then there's the information that she is pregnant. So, Your Honor, I'm not objecting to a $35,000 personal, but I do believe a tether is warranted here, in that just as Livingston County hasn't seen him for 4 years, that we will not see him if he does not have something to keep track of him. And that's why I'm asking for that tether, Your Honor.
22-year-old lifelong resident, Your Honor, indicates to us that he has one child, full-time barber. Respectfully, Your Honor, he understands there's going to be no contact with the complaining witness in this matter. He understands where he's going to be. Livingston's going to have a chance to come pick him up if they want him, Your Honor. So, respectfully, my client denies these allegations, indicates to us that the first time in which the child states that that he's seen my client push his mother against the wall, what fails to be said is,
after watching this lawyer in a few cases, he has a unique way of starting his lawyer talk. One of them is what he just did, where he drops in what he says the prosecutor leaves out to make it either look like the prosecutor has made a mistake or that the prosecutor is trying to deceive. And this type of manipulation of the truth, which I call lawyer talk, and this type of talk comes so natural to some lawyers that they forget to turn it off. So let's go hear what the prosecutor has apparently left out.
indicates to us that the first time in which the child states that that he's seen my client push his mother against the wall, what fails to be said is the complaining witness, which my client indicates to us, the complaining witness was initially hitting him.
See what I mean? He starts it by saying that the first time the child saw him push his mum against a wall, that it's the child that indicates that his mother was shoving his father, and quickly slips in that the clown here said this to him. Lawyer talk, it's like when a liar speaks.
And the second time he indicates that the complaining witness just wanted him out. She knows she wants him out, and he doesn't want to be there. So respectfully, Your Honor, no objection to the personal bond. We're just asking for no tethering.
So he's got somewhere other than Calvert to live?
He does, Your Honor.
How many hours does he work?
Indicates to us that he's a full-time barber.
I'm a full-time magistrate. What kind of hours does he work?
Mr.
I go in from 9 to 7:30, and then after I work from at the barbershop, I work from Pastor Mo with the no beef zone. We go to different schools, talking to the bad kids.
What a clown. He goes and speaks to troubled youth about staying out of trouble. I bet when he told his lawyer this, that his lawyer mustn't have said to him, "Don't say that to the judge, as you'll look like a dickhead." And what do you know? This guy's head looks like a dick.
Well, sir, if you want to be example to so-called bad kids, maybe you should go to wherever you're on probation and get that situation straightened out. In the meantime, you're to have no contact with Miss Hale, no contact with the Calvert Street address. You will be on a GPS tether. It'll be unrestricted as to time and place, so you can move around and take care of your business. You just can't go to Calvert. Bond will be set in each case at $20,000 personal. Thank you, sir. You can step aside.
Good morning, Rob Jacob on behalf of Ms. Brookshire.
Marie Brookshire.
Judge states PCC, we're asking this matter for a preliminary exam. And
Discovery is complete.
Yes, Your Honor. I met with her at the jail last night. We went over the police report. I would ask if we could address bond.
I have a tether violation.
Judge, the only thing is, speaking with my client last night at the jail, is the violation is that she couldn't power up the tether. She's still wearing it. And she was released originally on PR bond with the tether. She had problems charging it. And I believe that's the violation itself. We're asking if the court would please consider just to really restore it back to PR bond. I would ask for without the tether, but if it has to be the tether, if somebody could look at it, she's still wearing it. It doesn't work. So we just need to get that straightened out. For my client, the tether was acting up when she was brought into the jail. So okay. I just think the tether people have to either come and adjust it or get a new tether, or hopefully without a tether.
Did she contact the company when the alarm was going off?
Your Honor, I did, but my problem was I couldn't see very well because my contacts, and I accidentally typed in 8100 instead of 8160, and my dad looked at it and we both double checked, and he couldn't see it. He put the wrong one, but I did leave 2 messages for Brian Levitt. He told me to charge it for 20 minutes. We agreed on 20, I did 35. I called him after to see what my percentage was. I left him a message. And when it was going off, I called him again, left a message. When it was going off, me and my dad both attempted to call. And my phone was dead, so I couldn't get his number. But
I don't have any of that information regarding any call to community correction or anything along those lines.
So I had the opportunity to read the community corrections violation report that I believe Your Honor has as well. And that's not what's reflected in the community corrections violation.
I don't, hang on. I have the sheriff's office report.
So I have a bond violation.
I do not have that.
Which I don't have. I don't know what it says, Your Honor, but I'm just asking if the court would please consider a lot.
Well, I got to figure out.
Mr. Levitt, and I can provide the court. Do you want me to email this over?
Yes, when you get a chance, that'd be great.
Yes, Mr. Levitt gave her very specific instructions. She was advised to charge it immediately after leaving community corrections, and she was told to, I'm still speaking, she was told to charge it for 2 hours. Mr. Levitt is the person that had to make contact with her while he was sending, he got an alert that the device had low battery. He attempted to contact her on the number that she provided him. That was unsuccessful. He started sending alarms and sirens repeatedly to the advice. Finally, the defendant, this finally, I should say, is, I'm really bad at math, 6 hours later, the defendant calls from a different phone number. He goes over the instructions with her again and says, I instructed them to charge it for 2 hours. She said she could not charge it for 2 hours. I told her it was her responsibility to keep the device charged and that it was critically low. And that's, excuse me, if it gets critically low, dispatch will be contacted. They acknowledged this when the phone call ended. They then only charged it for 35 minutes. So she was given very clear directions on what to do. That was from June 10th, the first time it being low at 1 a.m. Then June 10th, 7:47 p.m., we received another low battery alert for the defendant. All attempts to reach the defendant were unsuccessful. At 7:48 p.m., Washington County Dispatch was contacted, advised of the violation, and was asked to have an officer respond and take the defendant into custody. Contacted by Deputy Mace, who was on scene with the defendant. They were claiming they had been trying to charge the device and were unable. Deputy Mace was told they needed to be arrested on the violation. The defendant had only charged for a total of 45 minutes in the last 5 days. At 9:05 p.m., the defendant was tracking at the Washington County Jail. So the device is working. In addition to this, my office just charged her with stalking. It's a separate case. In addition to this, my office requested a $10,000 cash surety bond at the time of charging. This case being today's case, we requested the $10,000 cash surety on putting she's before Your Honor.
Mr. Kilwald?
I'm keeping the same argument, Your Honor. I'm asking.
Okay. Motion for bond reductions denied. Bond will continue. This matter is revoked.
Judge, it's clarification. Is the bond, what are you, $2,000, 10%?
What do you have this on?
No.
I have 2,010% on this case.
And if she's released, it's on tether?
It's on tether. She'll have the same conditions.
Okay.
What? Oh, no, she is not going to sit there and mouth me. Her bond now is 25,000.
Really?
10%. Yeah, really? You want to keep going? I didn't think so. Have a good day. 25, 10.
Have you ever heard of the rule of thumb? Well, I'll tell you a rule of thumb. Don't fuck with Cedric.